As Utsavam explores new dimensions to benefit art and artists, here's a session on knowing the difference between inspiration and infringement, and knowing your boundaries as an artist with insights of copyright law available. This session features the lawyer and dancer Saishruthi Krishnaswamy. She's also a recipient of the Parivartan Annual Grant 2021-2022 Fellow. Her topic of research is very relevant and important, and we're so happy that we're able to platform this talk, which was also her research grant at the Utsavam Festival. Parivartan, for those of you who may not know, is a research initiative for artists to spark research in the field of performing arts and allied fields, started by Ms. Priya Murli, who is here with us today, and myself, and with the able assistance, of course, of Sneha Mahesh. So join us for the session. Let me introduce Saishruthi to please come and take the stage.
A very good morning. Namaste. So I'm Saishruthi Krishnaswamy. I'll be presenting my research on inspiration versus infringement and what are the limits. So before I begin, I'd like to give a brief on what is copyrights and why we need copyright. So copyright is something that we can seek for artistic works, like let it be poetry, movie, anything that is artistic in nature. We can seek copyrights for that. And why we need copyrights is to protect your economic rights and the moral rights that comes along with that. So and then we have a concept called adaptation in law. So what is adaptation? I see an art piece, and now I want to adapt it into a movie. Maybe it can be a novel, which I want to make it as a movie. Maybe it can be a poem, which I want to make it as a song, whatever it is. Those are called adaptive works, adaptations of the original work. So the first and foremost aspect that I want to deal with today is fair use versus copyright infringement. So what comes under fair use? So fair use could be using anything for research. So if I am using a song for my research purpose, if I am using a song to teach someone something about the song, then all those will come under. So it is pretty much the non-commercial aspect of using someone's artistic work. Rather, copyright infringement is when you use it for commercial purpose. I'm making a song out of it without proper license or without the permission of the original author. All that would come under the ambit of copyright infringement. So in this, I would like to explain the case of Anupama Mohan versus State of Kerala, which speaks about unauthorized monetization over recorded video. So the facts of the case are there is a competition in Kerala which features Bharatanatyam artists. So in this, the organizer of the competition, he says that he will be recording the video, but he says it is for his personal use. So personal use comes under the ambit of fair use, so where he is not commercializing it. Rather, at the end, what he does is he sells the copies of those videos for money. So again, it becomes monetization of someone else's work. So here the court held that it was a clear infringement, copyright infringement, and the moment you start commercializing someone else's intellectual property without their permission, it becomes copyright infringement. And now I'll start with the crux of the presentation today, inspiration versus infringement. So what particular act of mine will fall under inspiration and what particular act of mine would fall under inspiration or infringement. So here we have the theory of idea-expression dichotomy. So idea is what is in our mind, something that doesn't have life yet. It is only in our minds. And expression is what you give life to. For example, we can take a lot of poems or padams that Bharatanatyam dancers do. So the idea behind performing that or the concept behind that would fall under the inspiration. So I see a movie, I want to make a dance ballet out of that movie. That is my inspiration. But expression would be where I choose artists and my characters are exactly the same. They are speaking the same dialogues or they are rendering the same, pretty much the same novel or whatever it is that is being produced as my artwork. That would fall under infringement. To be much clearer. I see that there are dances here. So we all know the Padam Indantu Vachitivira. It is very famous. So the first hand is always going to be, why are you here? Why have you come here? That is the idea. The idea is to show a Kandita Nayaka, basically, and to ask the Lord, why is he here? But the infringement would be where whatever the artist is trying to elaborate, whatever she's substantiating, like I saw you that day over there with that some other woman, whatever the idea, whatever she's creating, whatever she's expressing, if someone wants to copy or replicate the same, then that would be infringement. But if someone wants to use the same idea of, having a Kandita Nayaka asking why the Lord is there, then that would be just idea. So this is the basic differentiation between idea and expression, that is idea-expression dichotomy. So if that is clear, I'll be moving on with examples of appropriation and misappropriations. Right. So the first misappropriation that I would like to explain here is a song by Solomon Linda. It's called Bube. So in that, they have tweaked the lyrics to that song and they have made it as The Lion Sleeps Tonight in Lion King. So unfortunately, I couldn't extract the audio because if I do that, then I'll be going through a copyright strike. So I didn't want to do that. So yes, so that song, if you all have time, please listen to that. The whole introduction to the song, having vocals and everything. Everything is pretty much the same in The Lion Sleeps Tonight, and this issue is still under dispute. And then other experiences, other few sort of misappropriations all of us would have been familiar is where we put some content on the internet and you see someone else performing that somewhere else and quoting that they have composed it or they have choreographed it, and it's their work. So with that, the first case, another case I would like to explain here is R.G. Anand versus DLX Films, 1978. So in this case, they've laid down 7 set of rules. I've just consolidated that to 5. 7 set of rules which we have to follow in case if you want to realize it for yourself, whether am I copying someone's work or whether it's going to be a true work in nature. In that, we can use this case, R.G. Anand versus DLX Films. So the facts of the case is that there is a novel based on provincialism. And then there is a movie produced by Deluxe Films, which is also based on provincialism. And it comes in the consecutive years. The novel comes first and then the movie. So here, R.G. Anand, he claimed that the movie was entirely based on his work. And then, but here the court said that it was not an infringed work because there were differences as to what was the setup. The provincialism is just a concept. That is just an idea. But how the provincialism and the issues associated with provincialism were expressed is what we have to see. So here they've told that no copyrights cannot be given for idea. Rather, subject matter, themes, narratives, historical, legendary facts, for all these components, copyrights will not be given. And then second one is where the same concept is developed differently. It is obvious that because of the source is shared, parallels are sure to appear. So since they have the similar source, there may be some sort of similarities between both the novel and the movie. But that doesn't conclude that the movie is infringed on the whole. And then we have lay observer's test. So lay observer's test is that as a layman, when I see a movie or when I see a creative work, if it replicates another work for me, then I have to understand that it has been infringed. So it's a lay observer's test. And the same, right. Next would be, apart from the similarities, if there are also dissimilarities, we have to count that in. So these were the 7 that I've consolidated as 5 here. So here I would like to play songs which I want you all to identify. I'll just play the initial 10-15 seconds of it. So please try to identify the song if possible. any idea on Kantara? Kantara or Navarasam? Whether it is Varaharupa or Navarasa. Now I'll play the other song. This is Varaharupa. Okay. This is Varaharupa. This is Varaharupa. And then the previous one was from Thaikudam Bridge, Navarasa. So here, as we all know, this was very recently, this was a case where Thaikudam Bridge, their music was done originally way longer. So they claimed that Kantara and their producers have infringed their original work. So here, if you understand, the basic pattern behind the whole song is pretty much the same. For example, the choice of ragas, the choice of talam, and everything is same. And even the starting portion of the song. For example, here you can, if you try to if you try to sing Kantara's Varaharupa along with this one, you will be able to actually, especially here, in all these pieces, all these places, you can identify elements of Varaharupa and Thaikudam Bridge, Thaikudam Bridge and Varaharupa as well. So this is the confusion that they had as well. So here applying this test, the third one, lay observers test. So what do we all identify? I mean, the case went around the other way, but that is only because of the jurisdictional issue that they had. It is not because of, the court have still not said whether they have the rights to use the song with respect to copyrights. They have only dismissed the case because of the jurisdictional issue, and not because they've identified whether copyright is there or not, whether it's a copied work, it's not given yet. So yes, this is basically the confusion we have when we speak about inspiration and infringement. So maybe taking the same raga is fine, taking the same thala is fine, but not the same musical notes, not the same pattern of the swaras and etc. So with that, I hope the part between inspiration and infringement is clear. If that is clear, I'll be moving on with why we cannot use copyrights when it comes to artworks. So now you might all wonder, why was she talking about copyrights and now she's saying we cannot use copyrights as such. That is only to understand basically what is inspiration and infringement. So yes. So as a Bharatanatyam dancer, and for all of us who are learning, practicing any traditional art forms, I would suggest that copyright is not enough for us. That is because, first of all, we need something called as originality requirement. In new current works that are still evolving, originality may be there. But in works that has been passed through generations from our gurus, from their gurus and everything, over there we cannot find the element of originality because it has been passed through generations. And second, the author requirement. For many compositions, we still do not know who the original author is. Rather, it's simply given as Krishnadasar, Ramadasar, something like that, where they go by other names. But we still are not able to identify the authors precisely because, again, it was done thousands of years ago. Third one would be fixation requirement. So fixation requirement means when I produce something, when I create a work, if I need copyrights for that, either it has to be recorded as a video or as a photograph or as even written. So either way, we have to fix our creative work. And then the fourth one, which is something personally that I don't like, that is limited term of protection. So in Copyrights Act in India, we have only protection for lifetime of the author plus 60 years. 60 years after the demise of the author. So lifetime and 60 years after the demise is the only period of protection that we have in India. But however, again going back to the compositions that were passed to us, it was taught by my guru to her guru, from her guru, and it goes on. So now I cannot identify from which day I have to calculate this lifetime plus 60 years. And after that 60 years, it enters the public domain, which means that anyone is free to use. So your intellectual work, if someone is when it comes to traditional art form, it was done way earlier. So if someone is able to use person X work after 60 years, then I don't think it holds good value to what we what we have learned in all these, with all these compositions. And then there are other concerns that copyrights fails to defend. For example, what happens? So now we have seen scenarios where it is from one artist to another artist. An artist, they copy it from another artist. But what happens when your cultural identity, that is, for example, if you are a Bharatanatyam dancer, and there is some sort of misrepresentation of Bharatanatyam, then that is not being protected in copyrights. So, or when you are a musician, if you are, maybe a violinist, whatever it is, if it is being misrepresented anywhere. For example, we had an advertisement where they had Bharatanatyam dancers dance in regular, costume in their regular classes, where they see one Bollywood hero and then they all run towards that Bollywood hero. So we have such misrepresentations of art as well. So what happens to that? All these are not covered, or they're not given enough protection under copyrights. So that is why, in my opinion, we need UNESCO's model provisions. So WIPO, that is World Intellectual Property Organization, and UNESCO, together they have brought in model provisions which holds good for traditional cultural expression. Here they call all these art forms as traditional cultural expression and not as artistic works. So, and they also go by other term, that is folklore expressions. So the threat now that we have is the community loses its identity. So as I said, there are misrepresentations because of which the community loses its identity, and misappropriation of TCE, economical loss, and loss of livelihood. These are the threats that we have, since copyrights is not enough for TCEs. So now I'll be explaining briefly the 14 sections that we have under the WIPO UNESCO model provisions. The first one is that Section 1 mandates states to bring in a sui generis law or amend the existing legislation. Unfortunately, so when I speak about sui generis law, it means something new, a law that is especially for protecting TCEs. Unfortunately, in India, we do not have anything that explicitly protects TCEs. We always fall under copyrights or neighboring rights or performers' rights, but we do not have anything that is specially curated for traditional cultural practitioners' expressions. And next, we have Section 2, which makes it clear that term works can no more be associated with TCEs. The term expressions and productions are to be used. So, as I said, we are no more, it's no more an artistic work. We have to call it as traditional cultural expression. And then Section 4 lays down certain exceptions. As I previously mentioned, in copyrights, we have fair use. Similarly, we have educational purpose, fair use, and borrowed expressions. All these, provided we quote from where we have borrowed. So that is also there here. And then next, Section 5 speaks about acknowledgement of sources. So you perform something, you have taken a varnam from someone, you have taken a composition from someone, quote them, thank them wherever you can, or just mention that they are the original composer or they have written the song, whatever it is, mention that. And then 6 speaks about where they are dealing with offense, that is any person who willfully or negligently violates the provision under Section 5, that is whoever is not acknowledging the source. Any person who uses the expression without authorization, that is without permission, and then any person who deceives others about the origin of expression, that is borrowing someone else's work and saying that this is my work. So for all of them, punishment is available. And Section 7 deals with the punishment, that is seizure. First of all, and then there are other actions also. So what they do here is they seize the property. If it is some sort of cassette or CD, whatever it is, if it is a seizable property, they seize it, or if they can take possession over it, they can take possession over it, and then they evaluate the loss, that is unlawful loss or unlawful gain that has happened by using the expression. Excuse me. So unlawful loss or unlawful gain, they calculate that, and based on that, the compensation will be provided to the party who has suffered the loss. And next, Section 8 mandates every participating nation to provide civil remedies for unauthorized TCE expressions. And then Section 9 says that member countries to constitute authorities, panels, supervisory bodies. So again, since we are not aware, in India, since we are not aware of TCE, we do not have any authorities or panels which can take over cases with regards to TCE exploitation. And then we have the procedure that has to be followed by the authorities. And then Section 12, relation to other forms of protection. That is, while seeking protection under TCE, it is not to interfere with other IP systems. That is, if protection is available under performer's right, you can also seek that. But TCE will be in addition to whatever that is available, and only for the traditional cultural expressions. Right. So with this, we understand the lacunas that the Copyrights Act have, and then if we are able to bring in UNESCO WIPO's model provisions, a sui generis law, or maybe an addition to the Copyrights Act that we have as of now, or whatever it is, if we can bring that addition in the legal system, then I think it would be great for people practicing traditional cultural expressions. Right. So with that, I would like to move to my conclusions and suggestions. As I've been repeatedly saying, copyright is definitely not enough to protect traditional cultural expressions or folklore expressions. And because of this lacuna in the legal system, it definitely paves way for more exploitation day by day. And then I also have received few opinions from experts and activists who are associated in promoting protection for TCE. That is, they first say that the communities are unaware of their rights. And until very recently, even I was not aware of UNESCO WIPO's model provisions. So the communities are also definitely unaware of their rights. The communities do not come forward to make representations against misuse. That is definitely because awareness. They are not, first of all, aware that someone has taken their work and they have reproduced it. And second of all, they do not know where to approach. Who is the concerned authority? Which body do they have to approach that they are not aware of? And because of which, in India, we do not have a solid case present to say that the traditional cultural expression has been violated. And then communities are unaware of the rewards earned by the exploiters. Even if they are aware that their work has been copied elsewhere or by someone else, they're not aware as to how much they earn by such exploitation. And then the suggestions, as we all know, a sui generis law should be brought in, a legislation should be brought in to especially protect traditional cultural expression. And then awareness is something that we need right now. And then rights over TCEs are to be vested with the communities. So when I say rights over TCEs are to be vested with the communities, it is the community that we create. So even though if we do not have a particular community as of now for each and every art form that we have, we can do it by registering them through Societies Act. So if we can do that, we can get recognized as a community, traditional community or an artistic community, and we can gain all the benefits that comes with this act. And then awareness to be created about the rewards and exploitations, and a panel to be established to address issues dealing with TCEs. So these are my suggestions while bringing in this law. So foremost suggestion would be to bring in WIPO UNESCO's model provision. So with that, I conclude my presentation. So if there are any doubts or anything with regards to the presentation, yes.
Are you working on your suggestions?
Sorry?
Are you working to implement some of
Yes, we are actually. We are planning to work on. We have had leads from, thanks to Priya Murliakka. So she has suggested that Abhay will work on this shortly. So they'll take measures for that with me. Okay, Abhay is All India Bharatanatyam Artists Association. So they have been dealing with all incidents with regards to any issue that a Bharatanatyam dancer or even for other artists, they've been providing guidance, not just for copyrights issue, for everything. So Priya Murli Akka, we have Priya Murli Akka here. So she is the vice president. So she has said that we'll work on it. So we are working on it.
You have a record, either it's video or in writing, and it's your own work, whether it's research or whatever, or a performance. So you can actually copyright it now?
Definitely. Wait, so what I'm saying is, so your doubt is whether I can copyright my performance. Right, as of now, with whatever law that is available for us at present, I can seek performer's right for that, and I can also seek copyrights for that. But again, if someone is going to use that, as we all know, if they are going to use it for fair use, then I will not be able to seek any protection from that. Okay.
I'm talking about people who use it without telling you, without letting you know, and they're lifting it really.
Oh, okay, it's not me who is recording my performance. It is someone else who is recording my performance. They cannot. They cannot, because it is my expression here. It becomes my expression, so I have to record it. And if I am authorizing that person to use it, they may use it in whatever appropriate way that is available to them. So I think that happens to all the performers.
This is just a comment. Komal Kotari of Jodhpur took to court the exploitation of the Manganiyar music by Bollywood, and he won. So they were using the songs from the Manganiyars, and they had to pay a big fine.
I have a question. It's about visual arts. I don't know if you can help us. I've learned recently that if you purchase a work of art, a piece of visual art, you of course, you have the image, you have the painting at home, but the artist still retains the right to use the image and to sell the image for other purposes. They can sell it to a t-shirt company or a company that makes, mugs or things like that. Is that right? And if so, then when I purchase a work of art, should I also then incorporate this thing that, it should not be then sold as an image for other purposes as well?
Right. Your purchase would have been under the category of licensing probably. So your purchase would have reflected as licensing. So when you license, you are just one of the people who are seeking license to that property. So similarly, they can also give it for license for, as you said, maybe a t-shirt or maybe for bags, whatever it is. So maybe your purchase would have been considered as licensing, and that is why they are able to give it to others as well.
So then, is it necessary then now when you purchase a work of art to also then incorporate all these elements into it and say that I'm purchasing the work of art and I will also then potentially or possibly use it, for and monetize it on t-shirts or mugs? Is it safer then to incorporate that straight away in the purchase of a work of art?
It is to be explicitly mentioned.
Okay.
Saishruthi, thank you.
Thank you so much.
Actually, we are very happy that she applied for the grant and we gave her the grant. Of course, this is only a kind of we're only stoking it, and it's the initial spark. We have miles to go. So basically what we understood, you can correct us, is that there is no copyright law to say I'm a dancer or any traditional arts. You call that traditional cultural expressions. So you don't say Bharatanatyam or anything. So there is a nomenclature over there.
Yes.
And then secondly, there is no copyright law per se that protects us. So you are suggesting the WIPO UNESCO guidelines, which means we need to take this. The next step would be for us to take these guidelines and go to a registered body. I mean, if we need to bring in as a law, we now as artists and maybe with the help of other people, influential people, we need to go and represent it in the government to make it as a law, because Preeti, I'm sure you've also grappled with the thing. The other thing is, also the question is when a guru is teaching you something new, remember we were talking about it, and again, sometimes copyright issues happens when the guru and the shishya fall out. What are the copyright laws? Because you have paid fees. So many other things are there in it. It is a very complex procedure.
Yes, Akka. Based on my understanding, it falls under the ambit of acquired knowledge. It is not a stolen knowledge. So
Okay.
for acquired knowledge, you can definitely not say that even though I've learned it from my guru, I cannot, that doesn't, that there can be no restrictions with regards to copyrights because that is an acquired knowledge. So you know that you are teaching your student something, so you are aware that your student has learned it from you. So that becomes acquired knowledge, not a stolen knowledge. Yes, if it is definitely for non-commercial purposes, absolutely.
So there are so many issues. It is not a very simple procedure, and I think at least I can say that from the point of view of a performing artist, or even as an artist who's painting or something, there is so much of, we don't know what is there. So for us to do this, first we need to see if this can be, that is what I've been telling Shreya, and I want to see if this can be applied and actually artists, get their copyright and things like that. Anything Bollywood. Now you have Ilayaraja who said that SPB couldn't sing any of his songs. So many things are there. So I think, first of all, as artists, we also need to come to the other side. That lacuna has to be bridged. And I hope Parivartan we can help in that. And yes, I would also try and keep your this thing in the Association of Bharatanatyam Artists, which is one of its kind basically in the field in India, because not many traditional arts have association. We are trying to address many issues, including the Me Too issues that is quite rampant. But I thank you, Shreya, and thank you, Debbie, for allowing us this, because I think this is the need of the art. Yes.
I'm an artist, traditional and contemporary. So as artists, we put our works in a gallery, but most of the time, when we want to stand in front of the thing, we post it in social media, in FB, in Insta. What happens is, they steal our paintings. I don't know if I can use the proper word stealing, but they use poets, copywriters, everybody without any permission of any sake, they post it with the painting, not even giving a credit to your work. Now what do?
You can definitely go for a copyright strike in that case. Even though you have uploaded it on your social media handle or even your academies, whatever it is. But if it has gone from you, then you can definitely file for copyright infringement. And even if someone else has uploaded your work, you can still go for a copyrights claim on that.
There are so many things I like what you say. It is a scenario, I don't know how to express it in words. It is so much of put it in your, as a creator, you know, the pain. When you create, it's your own stuff. It's your own expressions, your own feeling. But when you see in somebody's work portrayed over there, and when the credit goes to somebody else person, it is fully haunting. As an artist, I think everybody can resonate with my feelings.
Definitely.
And I don't know how to go about it practically.
Okay, right.
Practically.
Right, okay. So for...
I have one question also. So many museums, they own paintings. Then they make prints of these paintings, which they sell. So we have also been encouraged we have a large collection of paintings, both traditional and contemporary, to make prints of these, frame them, and sell them in our craft shop. Now, whatever, there are many, like if it's a Tanjore painting, we don't know who's painted it. If it's a glass painting, we don't know who's painted it. If it's a contemporary artist, we know who's painted it. We would put the name on the back of the print. But do I need any permission from an artist to do that? Because the paintings are in our collection. We own them.
You own the art collection.
We own the art
and you're
collection.
getting copies of
and we're taking copies of our own paintings, making very high quality prints, and framing them and selling them. We haven't done it, but this is what we've been advised to do.
Okay. Yes, if you own the painting, maybe you would have acquired it from someone, maybe you would have bought it from even the original creator.
Yeah.
In that case, if you want to sell copies of it, you're free to do that.
And like
But-
what Anita said, if we want to put it on a mug or something else,
Yes,
then we will do it. We have done it actually for tribal painting. We've done it.
yes, that is possible. If you own the painting, then that is possible.
Can a tribal artist, if you take the Warli or the Madhubani Gond painting, they have a certain style. Now, everybody is copying that style. They're putting them on saris, they're putting them on cushions, they're doing paintings themselves, but there's never any, recognition of where that art has come from. Can these tribal groups, can they apply for copyright?
That is why we need the TCE protection here.
So you're
WIPO,
saying
UNESCO's-
now we cannot because we don't
If
have a
that is
cultural-
available, we can, because here we are protecting the community as a whole.
Yeah,
And then we are also, even if we are not able to identify the author, the community can seek protection on behalf of the author.
Yeah, because there's a certain style for each one.
Yes, maybe in that community we are not exactly able to locate that particular individual who created that piece. So in that case, you give the credits to that community, and then the community can seek, benefits from your, if you are trying to use that somewhere, and through that, the community can benefit by monetizing that.
So this is something that you're working on and your
Yes.
suggestions?
Yes.
Okay. Thank you.
So we were talking about paintings. So I had a very peculiar situation. Somebody had put my dance photo in their Facebook. And when I contacted, they said, "Why the hell have you got my photo in your thing?" She said, "No, I just thought it was a very pretty photograph." So what do you say to that? So that's the kind of, people just do things they just take somebody's photo and put it in their Facebook thinking it's a nice thing to do. That's how scant respect for anything original or anybody's mug or anything like that, So it's a big process.
I just want to share that something for Parivartan to add to your collection in this regard. There is a booklet that came out called the Copyright Kotwal.
Okay.
And this was done by Praveen Kannanur, who under the India Theatre Forum. So the instigation behind this was some 10 years ago perhaps, a very famous playwright from Chennai, Indra Patsarathi, called Praveen and said, "Look, so-and-so, okay, I'm not mentioning names, so-and-so from West Bengal has quoted being inspired by my play and has written word for word the same thing in Bengali and published it as his play." Now, both are fairly well-known playwrights. And this poor man is in his 90s, like, where do I go? Frankly, we never turn to the law because the law is so slow in this country. At best, if there is any kind of a fame associated, there's a defamation that you can benefit from. It may affect your sales if there is a lawsuit attached, etc. But you have to be like SPB, Ilayaraja, Shubha Mudgal, again, who had a copyright issue. For the lay person or the normal artist, like the rest of us, the Indian legal system is of no use. It's not like in the United States where copyright infringement can attract penalty immediately. Things get halted, you get seized, you get fine slapped on you. The system does not work in favor of not just copyright, but generally, Indian legal system is really of no help to anyone, frankly. So this is my query of how to make it work for you. Even if it is granted in your favor, there'll be X, Y, Z things you have to put into place after that before you can retrieve a license. It tires out the applicant. It tires out the person seeking justice entirely. That was on the one hand. The Copyright Kotwal is an interesting document written together with with a lawyer working with the arts. And what it does, it gives instances like you have of fair use and seeding it, infringement versus inspiration, many case studies of what could be better use. Now, on the one hand, we're talking about monetary profit. That is at one level where you can immediately say, hey, don't steal it, or there should be some sort of a royalty at least that goes to the creator or the family of the deceased creator, whatever, etc., if it is talking in that level of money. But at another level of just ideas, where there is not negligible profit even to talk of, which is the case of most dance or music or any of the other kinds of art we are talking about, then fair use is what we are hoping for, because there is nothing more than that you can insist upon. So these are some of the thoughts that came. The Copyright Kotwal is an interesting book to add to your list of things maybe to look at. What would you do? I mean, you talked about musical arrangement being one of the things to, if it is text, it's easy to look at words and say, okay, you've repeated the same thing. Musical arrangement, still a little bit dicey, but yes, you can, When it comes to movement, very hard to copyright. Very hard to copy, unless it is very word for word traditional Bharatanatyam, things which even then no two performances are alike. What happens in the case of improvisation? So these are areas to still cull out. There are some models in other parts of the world that have dealt with it in a certain way to look at, but would love to work on that further.
Right. Since you mentioned movements, so in dance especially, if you see one of your adabus being done by someone else, then you will not be able to seek any protection. But rather, if it is a corvée of movements, if it is a chain of movements that is so similar to yours, then you can definitely seek protection. But again, the measure or the meter that we have to calculate, whether it's a chain or whether it's a singular movement, that is still little dicey.
Yeah, I mean, I've stated the issues of going legal or not, of not being of great value, but the case rests. I think it's work that is important that has to be done.
Definitely.
Is there any body now, say suppose there is something that is being copied, leave this, but there is nothing that we can go and say, hey, there's an infringement. Not yet.
As such, I mean, I'm not understanding.
Nothing else, like suppose
the regular court process is what we have.
IP.
Okay. The appellate tribunals are there.
Okay.
And then
how long does it take?
There is no, I mean, even though they have given, by law, they have given 60 days to decide this case.
But it's not enough.
90 days to decide this case. And again, they follow it by in necessary, or if it is necessary, the court may seek extension. And then that extension is like forever.
And one more question, you have civil lawyer, criminal lawyer. So do you have any lawyer who specializes just in copyrights or artistic infringements? You are the... Okay.
Bunch of senior lawyers, I can tell you, who's worked, I think the document, they did this document about 10 years ago, I think. I think it's called Copyright Left and Center. Okay. So it again talks about these issues. Again, it's to deal with theatre and, sort of performing arts. I can give you the contact.
So thank you so much. I think this is what we all need. I'd really wished more dancers and people from my fraternity had come. I did put it out, but I guess many things are happening in the city today. But thank you so much, Dakshinachitra. And it's part of the Utsavam, and I hope it's such a landmark place. Chennai is kind of identified with Dakshinachitra. And recently I had a couple from Orissa who was so happy coming here and finding their own stalls over here and getting us, gifts. So this is a very important place, and I'm so happy that Parivartan, Shreya and I could have Saishruthi. And Saishruthi, I hope we really make strides, because I think this is the need of the hour, and what is all these grants if we cannot take it further. So with the help of people, we'll get in touch with them. And
definitely.
And thank you, audience, for being so interactive. Thank you so much.